Usually, the initial question that clients have of me is to bail or not to bail. The first thing to realize is that although bail is set pursuant to a schedule so that every crime has a scheduled bail set for it, but that schedule can be deviated from by the judge. The only time the attorney can address that issue is in court. So that means that the defendant is going to have to stay in custody until such time as he either appears in court or is bailed out. The important thing to remember about bail is that because it can be increased, it is much more likely that that bail will stay the same if you've already posted it and you've appeared in court pursuant to the bail bond that you posted. So let's take a situation where we have an expensive bail bond, a $100,000 bail bond. The client's questions usually come in the form of, well, can we get that reduced so that we don't have to pay so much for the bail bond? And the answer is, well, we can try. We can appear in court at the arraignment, which is the first appearance in any criminal case, and we can make the request of the judge to reduce the bail. But the prosecutor can argue against that, and in addition can ask to increase the bail, so that there is a danger to the defendant by waiting that period of time and making that request while they're in custody. So I usually find it much better to bail the defendant out if at all possible, and the reason for it is simple. By bailing the client out, he's not going to appear in court within 72 hours. Usually, there's going to be a 30-day period between the time of the posting of the bail and the time we initially appear in court at the arraignment. By utilizing the time between the posting of the bail and the initial arraignment, it is much more likely that an experienced defense attorney is going to be able to prepare an argument as to why that bail should not be increased, as opposed to having to go into court within 72 hours and making that same argument. I utilize the services of Steve Muir Bail Bonds because my relationship with them has been built up over decades. I know the company, I know its owner, and I trust them. Clients, when they're faced with the initial question of whether or not to bail out their loved one, are faced with a decision that they are ill-equipped to handle. By utilizing a bail bonds company that I trust, I know that we're going to get my clients out of jail as quickly as possible.